what I would like to do also at this point in time, and after a day and a half of very thought-provoking contributions, just to now actually invite every commentator to give some comments about the last panel, about dispute resolution in general, whatever you want to actually say after I've listened to the day and a half, what's left over to comment on, basically. And I start with Nadia because she has also has a plane to catch.
Okay, so I'm going to love you and leave you, as it were. They say mediation is a future-focused process, and we can shape the future, or parties rather can shape their future. So I'm going to start with a few ideas about the future drawn from the presentations over the last day and a half, but particularly this afternoon. So I got three ideas, and the first idea actually draws on how Tony's comments at the beginning of this afternoon session about silos. And I really would like to see the future with the silos broken down, the silos of litigation, arbitration and mediation, or determinative processes, advisory processes and facilitative processes. And I mean, we see the beginning of that starting to happen. I mean, I'd love to see that disputants, whether they be states, corporations or individuals, have informed, which is really key, and easy access to a range of dispute resolution processes, and there are many more than just those three that I have named. And that means a greater role for clauses, not just mediation clauses or arbitration clauses, but as has been mentioned, multi-tiered dispute resolution clauses, which are increasing and of increasing sophistication also. But it also means it's not just private contract, it also means robust regulatory frameworks that encompass not just arbitration, not just litigation, and not just mediation, but all three, and an increasing role for institutions across jurisdictions, so multi-jurisdictional institutions. And you know, we've seen a presentation earlier in relation to the Dispute Resolution Authority in Qatar. We've heard a lot about Singapore and many jurisdictions where there are developed ADR services provide good models for this as well. So that's the first idea, break down the silos, because these processes are complementary and not in competition. The second idea is, and this is picking up in particular on what Jeff and Michelle had to say, that mediation really does have, I'm from a mediation background, unique features which have particular advantages to small states. We've talked a fair bit about the cost, but there are also unique features. Mediation has the ability, and I have seen this happen in my work, particularly in the Pacific, to build a bridge between introduced Western law and customary law, which is still alive and well. It's something different. Contemporary mediation is different from traditional dispute resolution forms, but contemporary mediation can build that bridge. Mediation also doesn't have to just focus on strict legal categories, right? So is a dispute commercial? Is it political? Is it environmental? Is it about family? Is it about all of the above? Is it about land? All right? What about legal standing? Mediation can move beyond some of those categories, and that can be extremely useful in solving particularly complex cross-border issues, where you can come at it from a number of jurisdictions. And I think we all know situations where you've got the government working at it from at some level, you've got lobby groups working on an environmental level, and then you've got some people with legal standing looking at the commercial aspects. And to some extent, all of these initiatives can be working against each other. And the other piece that has also been mentioned is the flexibility of mediation, and that includes ODR, on online dispute resolution, as Jack talked about, including cultural norms. I've had some great experiences in the Pacific where, for example, this is just one example, in Samoa, looking at cross-border mediations where we were talking about Samoans living in New Zealand and Australia who had invested in businesses in Samoa, but they were, so they all spoke the Samoan language, although they were New Zealand and Australian nationals going into business with Samoan nationals. The mediators decided, I was co-mediating with some Samoans, two Samoan mediators, and they had a big discussion about whether we should use the traditional orator language, which was traditionally used for dispute resolution, or whether we should use regular Samoan. And if originally people thought we should use the orator language because, that's part, it's part of our custom and it's a rich language and it's fantastic and it's always worked with land disputes to some extent. And then they realized, no, contemporary mediation, and this is what Jeff brought up, is contemporary mediation levels the playing field, right? Our orator language enforces those power differentials. Right, so we don't want to use that, but we can be flexible enough to change that, or even use both. You can use insider mediators, locals. You can use outsider mediators, or you can use people who are sort of insider and outsider. Right? Your choice of mediators, it's different from how you might choose an arbitrator as well. Right? Depending on whether you want someone who does know everything or someone who actually knows nothing. There's an enormous amount going on. I'll be brief. There isn't an enormous amount going on, and Desley's comments about there not being a lot of information about mediation in the Pacific just reminded me that it is confidential and that we probably need to write up some of the stuff that is happening. In some countries there are quite extensive systems with court referrals, and there is a very healthy commercial mediation scene for domestic and cross-border disputes. So that was the second theme. And the third one is enforceability. So a lot of people jump up and down and say, well, mediation's well and good, and maybe domestically it's okay because you'll get a mediated settlement agreement and that can be enforceable within one jurisdiction, but as soon as you do something cross-border, it's all up in the air. All right? Well, I mean, it depends, but insofar as you might want to enforce a mediated settlement agreement in a foreign jurisdiction, there are a couple of things just to take note of now. I thought Jeff was going to mention it, and I think he was just trying to be brief, but he didn't. A number of jurisdictions, and Singapore is very strongly promoting this right now, are using a process called Arb-Med-Arb. All right? So you put a big mediation window inside an arbitration that you basically just open. It's very streamlined. Use a different mediator for a whole lot of ethical reasons, and if you have a mediated settlement agreement, you end up with a consent award and can take advantage of the New York Convention. Point one. Point two, UNCITRAL right now, as we speak, are working hard on issues. They have a working group working hard on enforceability of international mediated settlement agreements. They're looking at preparing something parallel to a New York Convention for mediation. And it's a pretty healthy pace. I don't think we'll have to wait that long before there's an outcome in that regard, and that will address that issue. And my last point is picking up on Gary's and Petra and Jack's bit to bat. And I'm thinking, well, look, if we're going to have to take a long time to develop this BAT idea, sort of was a bilateral arbitration treaty, let's think into the future and not make it a BAT, but make it a BAMAT, a bilateral Arb-Med-Arb treaty, because by the time we get to the BAT, mediation will already be there and we'd be looking for the BMT. So let's just give users the choice and create a regulatory framework that is robust enough to manage all of these processes. Thank you, and I'm going to get my plane.
Thank you very much, Nadia. You were the only one who hasn't been introduced. But as you could actually hear, she is one of the international mediation specialists, is a Clever blog author, very respected author, and you can read it in the program. Great. Can I just now invite ladies first to make your final comments?
Thank you. I must say I was very encouraged to hear the options that are available to small states. And out of interest for what the Secretariat can do, I'll highlight the role of advocacy. As a Secretariat, we should be able to encourage the uptake of arbitration and other international dispute resolution mechanisms by our member states and also the small states. And not only advocacy, but also to provide policy advice where required. In the past, we've provided technical assistance with regard to demarcation of maritime boundaries and ocean governance, and also support with regard to dispute resolution when it comes to World Trade Organization issues. The Secretariat also focuses on strengthening national capacities in the form of capacity building for public officers. And presently we are engaged in discussions with the Advisory Center for World Trade Organization Law in Geneva on how to roll out more the training of trainers programs to have trade officers and legal officers at national level with more competence to deal with WTO related disputes. When it comes to the Hague Conference of Private International Law, the Secretariat has observer status, and we have ensured that member states, including small states, participate in regional meetings. We had one in Trinidad last year. We plan to have one in Guyana in collaboration with the Permanent Bureau of the Hague Conference. And we use the senior official meetings of senior officials of law ministries and also the law ministers' meetings to explore ways in which private international law can be utilized in the different jurisdictions. And my last point is, as a Secretariat, we are welcome to discussions on raising awareness for support to small states, in setting up relevant structures, and in partnerships, like setting up or discussing strategic partnerships with CITRO and other entities with regard to support for legal frameworks and any other mechanisms that would support IDR. Thank you.
Thank you.
Thank you very much. We're at the end of what's been a very rich conference, and it's hard to know what to say that hasn't already been said, and very eloquently, so I'll try to be very brief. First of all, I'd like to thank all those speakers who mentioned, and particularly Gary Bourne and Jack Graves, who mentioned the UNCITRAL instruments and the importance of them, the New York Convention and the model law on arbitration. It's clear there's a ready-made regime for the recognition and enforcement of foreign arbitral awards in the convention, and by our count, at least 22 states with a population of under 1.5 million are parties to the New York Convention. That's nearly 15% of all the parties. 7 of those states have adopted the model law. We would hope that there would be more states that would be in a position to do so, and we're working actively with a number of states to press that forward. What wasn't mentioned, in addition to those 2 instruments, we have notes on the conduct of arbitral proceedings, which are now being updated, and we also have a searchable database of case law on UNCITRAL texts, which is available free online in all 6 UN languages, which has hundreds of cases on a number of our texts, one of the most important being the model law on arbitration. So this is designed to help have a harmonized interpretation and implementation of those texts. So that is something else that we can offer. And to the extent possible, and particularly when we partner with the funding sources such as development banks, UNCITRAL can offer technical assistance to states, whether that is to legislators, judges, members of the bar, business parties, civil servants whose job is to implement these standards. So that's another service that we can provide. In the area of mediation, which we've just very interestingly heard about, there is a model law on international commercial conciliation, which has been in place since 2002. It's an UNCITRAL model law. I think there are perhaps somewhere between 20 and 30 states which have taken that on. And there is a set of rules, mediation rules, again, a product of UNCITRAL. They've been around since the 1980s. One of the areas we're looking at in terms of future work, which was already in fact mentioned by Nadia, is a process for a text, perhaps a convention, which would allow the enforcement of international settlements coming out of mediation, and that work will be developed over the course of the next year. Just a few words quickly on some future work which UNCITRAL is doing, which relates to all of these areas we've talked about. Our working group 2, which is a working group on dispute resolution, is engaged in looking at drafting a code of ethics for arbitrators, particularly arbitrators in the area of investor-state dispute resolution, but also in other areas as well. They're also looking at some means to approach and deal with the issue of concurrent proceedings in investor-state arbitration, or indeed any arbitration, so that you don't have multiple parties pursuing the same or similar relief in more than one forum. I mentioned already the text for the settlement agreements, and I guess that is essentially what I've got to say about what we're doing, except to ask that any member state, particularly small states, which have an issue or a need, perceived need for any of the services in this area that UNCITRAL can provide, please let us know, come forward, either in the context of the working groups or our commission, which meets in New York for 3 weeks starting at the start of July, or simply by writing directly to us, because the more we know your needs, either for texts that address these issues or for technical assistance, the more we'll be able to partner with you and provide some help. Thank you.
Thank you very much. Last but not least.
I don't know if this will go on. Can you hear me?
Yeah.
I usually say, can you see me, because I'm quite small. We've covered a few, quite a number of areas, and I have to say I've been educated, and I've been edified, and I've been by the process, and I've been honoured to sit up here twice in it, and it's been a great gift to me. And the gift that I would like to give back is that I'm a trustee of the Chartered Institute of Arbitrators. And if there's anything that the Chartered Institute of Arbitrators can do for you as small states for capacity building, or any advisory work we can do, or developing rules or reviewing our rules that might in some way facilitate any of your initiatives, I'm a trustee. I don't own it, I don't run it, but you have an ally there who will I'll do what I can to try to do that in the area of arbitration. And although we are the Chartered Institute of Arbitrators, we are very involved in mediation, as my colleagues will know. Michelle Kalipatis has been very involved in the Institute, as has Tony Willis and Jeff Sharp. We've a number of very prominent and very able and knowledgeable members in all areas of dispute resolution, including adjudication, including conciliation. This isn't an ad for the Chartered Institute. This is an offer that I'm saying that I will certainly do what I can to do that. Then, looking at it from an Irish perspective, I feel Ireland is a small state. It's a big small state, and I think that as people in small states would get a lot from a study of what has happened in Ireland. We initially, when I started in practice, we had the 1954 Act, I think, which was based on a something like Jamaican situation at the moment. Like when I heard that there was an argument about 1 or 3 arbitrators, I knew that was a reference to an umpire, I'm sure, which was in the Act, and it was very ancient stuff altogether. Anyhow, by the time we worked very hard lobbying. We were lucky to have some attorneys who were who we knew well, and we got a great help from David Byrne, I remember, in the 90s. And we got uncitral model law, and I have to say I would really recommend that you consider that. It's the uncitral model law, the New York Convention, the uncitral model law, and it gives a certainty, and people know what they're going to get when they go there. And we chose the uncitral model law for without tinkering with it, because we weren't London, we weren't Paris, we weren't Geneva, we weren't La Défense or Manhattan, and we weren't Dubai. So we wouldn't be able to compete in that way. But what we did need was certainty of people were going to deal with us and people going to come to Ireland. So we thought that we didn't want we didn't want to have anything unique. We want to have the generic. So you know what you get when you come to Ireland. A lot of people have been trying to promote Dublin as a centre for dispute resolution. I've never felt that. I've always felt that we should promote Irish people to develop an ability to be an arbitrator, a mediator, a neutral, and to build a capacity in that way. I would recommend that you're not seduced into the idea of establishing centres. I think it's much better to develop the woman power, the man power, in order to do it. And if you look at the Irish experience, you'll see that we have ICSID, we have the Washington Convention, the New York Convention, the uncitral model law in our legislation. I'm not too sure if we still have the regional, the old Geneva conventions there. Now, so that's basically, we've no bits, and we have only 3 WTO cases years ago, the Americans, and they were settled, I think. Two of them were settled anyhow. The courts are very supportive of arbitration, and I think that's a job that you need to do on your judiciary, because, and I'll come back to that again in a moment, because the judiciary can see arbitration and mediation as a challenge. They can see it as a competition. And we are very lucky that we have had universal support for arbitration and more support for mediation by the judiciary. Moving then to Desley Horton's presentation about the geographical span of it all, before even there was any mention by Professor Graves about the online dispute resolution, it did occur to me that since around the year 2001, I have been doing internet domain name disputes in the UDRP. And I would have done about 400, maybe more, about maybe 30 a year for the past 15 years. That's the kind of numbers I do. Now, that is online dispute resolution, and this is a very, very effective way. And this month, I have been instructed by, well, in the past 6 weeks anyway, by Kuala Lumpur, by the National Arbitration Forum in St. Paul, in Minneapolis, by WIPO in Geneva, by Nominet in the UK. And these are people who would appoint me, and I make decisions about people from all over the world, and sometimes decisions about people who don't exist, because they pretend, they make up names and they register domain names. It's a model you could look at, but certainly I looked at the Cisco, I was at the Cisco conference, the online conference in Dublin. I have to say, I also have used GoToMeeting, and I think that I didn't see much difference between them really. I think you probably.
The difference is price, but the price, the quality, I agree.
That was it. I mean, it was. But I think really, when you look at the geographical span, I say going to Desley's presentation, that's what you. I mean, the technology is there. And the remoteness, we have technology to deal with remoteness. And moving on to the BATs, I remain to be convinced. I think that one of the things about it is that sovereignty, whilst you say it's no intrusion on sovereignty, I don't know that would be the perception in the courts. And I also, coming from a small country, understand that the courts are... They might have a different view of things than courts in larger countries, so I think they might see it as quite a competition. I also think that the nation states would see any challenges to their sovereignty and would be very sensitive to that. Now, earlier on this year, Francis Gurry, a friend of mine who heads up the WIPO in Geneva, Francis came to Dublin and he made a presentation. He said that, look, he said, there's nothing happening in international agreements at the moment. He said, you cannot get people to make international agreements. It's a very cold atmosphere. You know, I'm not saying that it's impossible, but we know about the tensions that are out there, and it's a low ebb for tensions. So the idea of getting bilateral, and then my other problem is that how many bilateral agreements do you have? You know, these are small countries with small resources. So how many things they need a package, not individual things, and that would be my difficulty. Whilst I wouldn't be necessarily against it as in that way, I also think that depriving someone of the opportunity by default to go to court could, in certain jurisdictions, raise human rights issues. You know, I think that's very, 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 very fundamental. And as I say, finally, I think, you know, there are possibilities for new models. There are too many rules out there. There are too many options out there. There are new models. What is available to small states there are people. There are barristers. There are people like me. There are people like the people who can form teams and who can work together either at any stage of things. That's not an advertisement for me and my colleagues, but there are small teams, there are specialists, there are boutique firms who can do things, there are big firms who can do things. And why buy when you can rent would be my sense of a lot of what has been said here. Do you know? And from the point of view of expertise, there is a lot of expertise. I wouldn't go running down the rules. We have too many rules. But if there is anything in rules that we can do to help, I for example, am particularly interested in trying to get an acceptance for Med-Arb. Do you know, I can't see why you can't trust somebody to hear both sides of it. I hear the secrets as well and hear the whole lot. But at the same time, at the end of the day, be professional enough to put it all aside and do a rights-based decision if they don't cut the deal. Now, there are people in this room, and I think that any of the people in this room, I see a few of them nodding there now, Michelle. There's a few people in this room, and any of you that I know, I'd fully trust you to hear the whole lot and make a decision. Now, I would. That's the thing. So I can't.
Clean as the driven snail.
Well, do you know, but you have. I mean, well, everybody has biases of one sort or another. I mean, that's part of the way we think. But the point is that we can do an analysis at the end of the day. You know, and perhaps an expert determination or something on that, something along those lines. And I think my main problem really with the BATs is the lack of appeal, in that situation. By default, with lack of appeal, not going on to that. So thank you very much for having me. Thank you very much for listening to me rambling, and I hope to meet you all again soon. Thank you.
Sorry, one point I forgot to make, and I don't want to steal James's last word, but we did have talk of a very interesting talk of the use of technology in dispute resolution. Professor Graves took us through that. This is something that can reduce costs and increase the speed of dispute settlement, and it's something that our Working Group 3 in Untitled, in fact, has been working on for the past several years. We have come up with now a document which we hope will be approved at the Commission in July, which is a set of technical notes on online dispute resolution. That's this here. We had been aiming for something much higher, which was a set of rules. That fell apart for reasons that had to do with the difference between one part of the world, Europe, and the other part, the Americas and others, as to whether consumers could be bound by pre-dispute agreements to arbitrate, and that was a barrier which couldn't be crossed. But that is something that is very much that is very much coming, the use of technology, and we hope that these ODR notes can make a contribution to that. Thanks.
Thank you very much. So can we just thank the panel? For this, I will get my colleague, Dr. Eva Lein, who also has not been introduced, again, to close this conference. I just wanted to say this has been a fantastic conference. The fact that there's no time for question, that we actually overtime, I think shows how interesting it was. It also means, we ending on a note that there has to be another conference, of course, because we need to gather all your comments. Can I get Eva to?
Thank you. I'm going to be brief. So I just wanted to say a few words at the end of a very interesting and very intense conference on behalf of the organizers, Petra, Ronson, and myself. We really enjoyed it a lot. A big thank you to all the participants for excellent presentations, excellent debates. And as James Bridgman said yesterday at dinner, it's actually amazing that we managed to get all these people from these remote countries into one room. And those countries have actually fascinated us since we were children and read the travels of Captain Cook. So luckily today it's easier to travel, and you made your way here, and we thank you very much for this. Many thanks as well to the sponsors of the conference. First of all, to Wilmer, Hale for hosting this conference so perfectly, but also many thanks to Queen Mary University of London and to the Open University for their sponsorship. Finally, thank you to the audience for coming, for joining, and for very precious comments. And obviously we hope to see you all again soon. And maybe given the weather here, next time we could meet on one of your beautiful islands. Thank you very much.
Very quick.